Hello, Larry Armstrong, your real estate agent and advocate. We are here. We're in Judge Simpson's court, landlord tenant court. It's on fire. It's enjoyable. Did you check out where the attorney tries to take the blame? I'm not going to tell you what happens, but it's juicy. So check out that video. This is the continuation of that day. A different case where the attorney and the landlord, I believe it is playing fast and loose with discovery. Discovery is a part of the process that really helps the other side understand. Was something there that should not have been there? Was something done that should not have been done? And get a grip on, do they actually have a case or not? How should they settle this case, or should they go all the way to trial? Both sides get to look into discovery. And one side in this case is playing a lot of games. And I believe the judge said he was going to issue a bench warrant. So let's check it out. All right, come on in. Make sure you like, share, and subscribe, because inevitably there's somebody that needs to know what you already know. And we're getting ready to learn right now. All right, Judge, we're ready for court. Yes, we are. We are here. We're turning it up, keeping it loud. So unplug, protect yourselves, or at least turn down your volume. I'm doing my best to ensure that we can hear, because as you remember, we are back in court in person, and the mics do funny things when people say the best parts. All right, let's go.
All right. Thank you, folks.
Thank you. Have a great day.
Probably too late, but okay, I'll be back in. All right.
Oh, no. It's a good day.
Running out of people. Okay.
So this is Jackson versus Beal, because it's left other than
Jackson versus Beal.
yeah, Jackson versus Miss Jackson was present on Zoom.
Okay. And that's the one that we were doing. I got it.
Oh, okay. So I'm gonna turn off the closed captions, because that's not what they said. She was not the president. She is present on Zoom, is what his clerk was telling him. So they're getting it wrong. She's a
Where's my original? That's it.
accordion files. Yay. Good judge-like stuff.
All right.
Printed paper.
Court does call the case. Jackson versus Beal Properties.
All right, we're ready.
We just have to always remember, plaintiff goes closer to the jury box. But that's okay.
Did you see that? You hear that? Remember, we did a whole little overview of how you were seated. And there you go. Judge Simpson just told you, plaintiff goes closest to the jury box because the defendant is across so that they can be seen at all times. All right. Thanks, Judge Simpson.
Counsel, state your appearances, please.
Love being validated.
Hello again, Your Honor. Brent Ingram on behalf of plaintiff or defendant, rather.
Good morning, Your Honor. My name is Nicole Sunderland. I'm appearing on Plaintiff Tia Jackson, requesting permission to practice under Michigan Court Rule 8.120 under the supervision of your Edmonds.
Okay. So the landlord is the defendant in the situation. So that's why he kind of stepped up. He's like, plaintiff, I mean, defendant, rather.
Permission to practice is granted. Good morning. All right, folks, where are we on this case? What do we have today?
We're here today for a show cause hearing for the appearance of Stuart Beal. We don't believe he's here today.
That's correct, Your Honor. Mr. Beal informed me last night that due to illness, he wouldn't be able to make it today. However, Mr. Kennedy is here, and I believe that he can address any ambiguities that Mr. Beal was to address in terms of discovery.
This is the second time, Your Honor, on contempt of this court that Mr. Beal has failed to appear, and we believe that there's information that he would be able to answer that Mr. Kennedy cannot answer.
And I would counter that we believe Mr. Kennedy can answer any questions, and he is actually more than likely the best person, Your Honor, since he's intimately involved in this case. He prepared the amended discovery.
Judge, if I could just jump in, because I've been with this case a little bit longer than Ms. Sunderland. During
Just couldn't let her do it on. No, go ahead.
I
Fine.
was gonna let her.
She
do
was
it.
no, she was doing just fine, but go
She's
ahead.
doing great, but we're
I
gonna
know.
get the history that she.
Oh, okay, all right.
So during the deposition of Mr. Kennedy, there were quite a few questions that he explicitly said that he did not know the answer to. Mr. Beal would know the answer to. And Ms. Sunderland can't get into the more recent exchanges we had over discovery, which further point to the importance of Mr. Beal's presence here on the second date that the court ordered his presence, and that he has failed to appear. I'll let Ms. Sunderland get more into the specifics about the discovery.
Well, yeah, my understanding, and correct me if I'm wrong, as I recall, there was a deposition. There were questions that were not answered and could not be answered by this individual.
I believe that.
And that's why I ordered Mr. Beal to be here to answer those questions. We've been through this. And so if under oath, this individual can't answer questions, I ordered the person that I thought we all agreed would be able to answer the questions. And you bring me the person that couldn't answer the questions.
Okay. So everyone, all law nerds, say it with me. F around and do what? Find out. This is this moment right here. He put an order for you to be in court? Are you in the hospital? Have you gotten into a car crash?
In what world does that make any sense?
I don't disagree with your assessment. All I can say is that Mr. Beal was able to be here today. I have brought Mr. Kennedy in the hopes of facilitating if there are any questions that remain. They've had multiple bites.
He said under oath that he can't answer that.
I'm not sure.
So how's he going to facilitate anything?
I believe that the majority of those questions should have been cleared up by the two supplemental discovery answers that filed most recently, Your Honor.
I don't understand why he has that belief. You have pre-trial conferences, and those are, or should I say pre-hearing conferences, because whether you're in trial or not, you call up the opposing side and say, hey, I don't think we really need this motion to compel anymore because we've already given you supplemental responses. And then they say, yeah, but they're incomplete XYZ. And you go through this process of trying to avoid having to go to hearing. So this particular attorney should have no confusion that the other side feels that they have not fully complied. Okay.
And at this point, I don't know what their questions are that they still have before they depose them.
What? Okay.
Okay, we're going to run into a problem.
Ooh,
Well, Mr. Beal's going to run into a problem.
yes, he is.
And it's going to be a big one, and it's me. I ordered him here. You're telling me he's ill. Where is he?
Up around and find out. Well, don't you?
Where is he?
Right now, I do not know, Your Honor. I only spoke to him yesterday.
Okay. This is a show cause. So I'm going to suggest that you go out and you try to reach your client and let him know that I'm contemplating issuing a bench warrant. And then once it's entered, I'll let my friend here contact the sheriff's department. We'll go get it.
I don't understand why you do that, Your Honor. Though you told me that
Because he has not appeared. You can tell me it's an illness. You don't know where he is. He's supposed to be before the court. So somebody's going to answer for that today. I could just do it.
Yep.
I'm giving you the opportunity to contact your client, maybe talk some sense into him that he should be here.
Fine.
So I'll adjourn this. I'll stand in recess on this one until you can give me an answer.
understood.
Thank you.
Let's see.
Thank you.
Ms. Dendrinos swimming. I thought, Ms. Dendrinos, I thought you were done.
I am done.
Oh, okay, just hanging around.
No, I was just talking to my client.
Okay,
Is it October?
I don't know.
Oh, right.
Can you go see if Mr. Hughes and Ms. Kim are both still alive in that room?
They just went into.
They just went into one?
Okay. So he's talking about something different. We're on the Beal case. So law nerds, what is it again? Tell me again. What is it? F around and do what? Find out. So Mr. Beal is getting ready to find out what it means to disobey an order of the court, of Judge Simpson's court. You get a warrant for your arrest. And his attorney, not sure about him. I'm not sure about him because the other young lady who is representing Ms. Jackson, who is the tenant, but also the plaintiff in this particular matter, she is, I guess, just graduating or maybe in her last semester of law school. And in some regards, she's waiting to pass her bar. So she is under the directive of the ladies next to her. So in the beginning, she was like, my number L, so-and-so and so, can I pass, can I have permission to be before the court today? And the judge says, yes, permission granted, because her supervising attorney is right next to her. And that person is ensuring that she doesn't miss any particular facts. You saw her kind of intervene and kind of add some more pertinent information. And the judge kind of gave her a little ingest, like, hey, she's doing great. She doesn't need you to jump in. She goes, no, I just want to make sure you know these 1, 2, 3s. She's doing fine. I'm just making sure to add some depth to the information that she maybe didn't have. But plaintiff's attorney does not have a supervising attorney with him. And he has his own bar number. And so consequently, he's practicing and he should know better. There is no judge on this planet that gives an order and is like, oh, it's a suggestion. No, if you want to, you can comply. If you like the order, you can comply. It's up to you. Do as you please, litigants. This is just my little bitty suggestion. No, that's me. That's what I do, right? I'm a lady on Zoom in the computer, like the lady you don't know, and we don't have a contract with one another, like just giving you suggestions. But when the judge tells you to do something and he gives it to you in an order, it's not a suggestion. It's an absolute requirement. So being ill can be a response to not being able to comply to be in person. But you might want to, oh, I don't know, say, hey, attorney, since I'm ill, can you please get permission for me to appear by Zoom? Ms. Jackson on Zoom. Or can we get a continuance of the hearing until I'm not ill? Or you come down, and because that's if like you have COVID or something. Like I don't know what you could have as an illness that would say, I'm not in the hospital, but I can't come to court. Like if you have a broken bone and you're going in surgery and some kind of true emergency happened, then that's why the judge asked, and where is he? And he didn't respond and say, he's at Harvard General. He's at the local Memorial Hospital. So consequently, there's no real reason not to be there. So this is classic up around and find out. Please don't test the judge. It's not suggestions. Orders are not suggestions. Now let's see if he shows up. This is about as far as I got before I got on and decided I would come and watch with you. So let's see if he actually shows.
Okay, let him be. Yeah.
He was trying to get some more action in his court so he could do something else with his day. I think he has to just probably take a full recess. Okay, so he's gonna go. He's going on her. He's going dark. So let's. So 52 minutes.
I know.
What did he? So yeah, he probably got on the phone with his client around 52 minutes. Let's see. Come back on the record. Oh, an hour later. So we're about 20 minutes later, and I'm still looking for the case. Oh boy. Oh, okay. So we're now 30 minutes. Okay, we're 30 minutes. So let's see. Hopefully, the attorney has good news. All right, Judge, we're here. We're back. We're ready for court. Like, share, and subscribe. This is getting juicy. Is someone going to jail, Judge? What's happening?
I got it. All right. We're back in session. Got it. All right, court does recall the case of Jackson versus Beal.
Okay. Here. Are they there? I can see. Are they there? Oh, okay.
All right, counsel, state your appearances again, please.
Hello, Your Honor, Nicole Sunderland, appearing on behalf of plaintiff Tia Jackson.
Further move past the defendant.
All right, this is a hearing set up to show cause hearing regarding discovered responses. Is that correct? Have the parties been able to try to work out some of the discovery or not, now that Mr. Beal is present?
We have been communicating.
Well, you look at that. Threatening to go to jail can make a person feel well enough to come to court. Okay, be mindful. If you get an order to come in the first place, you really don't want to piss them off because, as Judge Simpson said, he could have just automatically put in the bench warrant. He didn't have to give that grace to the client and say, go to the attorney and say, go call your client. So don't F around too much because you really will find out.
Your Honor, and we did send amended discovery to them twice, in fact. So if they do have remaining questions, that would be something that they have not. Let me know yet.
Oh, did I pass?
You received.
Go ahead.
Wait, what did he say?
They do send amended discovery to them twice, in fact.
Oh, I meant
So
okay.
if they do have remaining questions, that would be something that they have not. Let me know yet.
Okay. So he's saying we've already amended our discovery, or they sent amendment discovery, and so they've already responded supplementally and so forth. So he's given them responses already, so he doesn't understand if they have anything else as a question because this is why he says he doesn't know what other questions they could ask because they've already answered them completely and wholly. Okay?
You received.
Go ahead.
Sunderland,
All right, go ahead.
We received the most recent response on September 8th, and we will concede that it's the most complete response that we've received so far, but given information that we have from our client and other sources to the information they provided, we believe their answers are still deficient. There are a number of documents missing from the discovery, and this has been after a supplemental request we made, their answers were previously deficient.
Okay, and what were those particular, what are the issues, I guess?
So there are 4 categories of documents that we believe are missing. There are a number of documents we think are missing from VISTA due to the inspections. We have a lot of documents showing that there were inspections that were failed and then later potentially cured, but there's nothing to support that they were cured or when they were cured. And we only have some of those documents from TIA. They were never brought to us by the defendant, by Mr. Beal. We also have documents from the city inspection of Ypsilanti. We received a certificate of compliance from April of 2021. We don't have any information from Mr. Beal before that we do have from TIA showing that there was a city inspection that was failed and needed to have deficiencies in the unit cured, but none of that was produced.
Well, hold on one moment.
Okay. So just to kind of break that up a little bit, Misha, I believe, is Michigan's safety inspectors, and then obviously the city inspector, she was saying, for the city, and that's the name of the city, Yulitsa, something like that, is the actual city. And so those are a different set of inspectors. And at some point they failed inspection, a couple points. And somewhere down the line, they say they fixed it, but there's no documentation in the plaintiff's possession from the defendant that says that they did, as a landlord, fix all of the deficiencies based upon the various inspections that were done by the third parties, which would have been the city or Misha. Okay. But I guess they have it from their own client. So they're probably saying, well, we know things exist that they're not giving us. So now we're wondering, what is it that may also exist that we don't know about? Because, they're not giving us what we already know does exist. Okay.
Hold on one moment, because there was a COC issued April of 2021.
CLC, Certificate of Compliance, meaning they are cured to operate this business, rent it out, whatever it is. I'm not sure if this is even a tenant of a residential property or a tenant of a commercial property. But nonetheless, COC means operation, Certificate of Compliance.
2022.
2022.
And
And that was what was produced by Mr. Beal in the most recent discovery response. But up until that point, we didn't have anything. What we had from our client was an inspection done in February that was failed, and there were deficiencies that needed to be cured. And then we have none of the communications and attempts to cure that deficiency, and we only have the COC in April. So we have none of that communication, and we only know that any of those failed inspections were prior.
timeline matters to them in the sense of, how much rent do I owe you? Do I owe you rent for March? You have a COC that says you are now, able to rent this out, but that's in April. So judge, I need to know if I should even be paying them rent the rest of February and March because they weren't compliant during that time. But if you have a clearance, you have a clearance. So, okay, let's see what judge
We
says.
only know that any of those failed inspections were prior.
So you're looking for something maybe from the city before 2022 on a COC?
So Judge, the tenancy began September 2021.
Okay.
And the earliest evidence that we have of a certificate of compliance is what was issued in, I believe it was March of 2022, backdated to October 28, 2021. So we have no documentation that there was a valid certificate of occupancy during the months of September and October of 2021. In addition, as Ms. Sunderland mentioned, those documents were ones that we had from our client. They are partial, just what she happened to still have, and they were never provided by defendant despite being responsive to our discovery request. So this is one of the categories. Ms. Sunderland can go into the others, but I want to emphasize that for each of these categories, they're both specific documents that we believe are missing, and the fact that those are missing, and again, some of them we have, but should have been provided if they were responsive, that indicates to us that there's a lack of completeness in the answers and the responses that we're getting.
All right.
Okay.
With regard to this first category, though, you believe that Beal may be in possession of something from the city.
Yes, and so this is
Okay, I don't mean to cut you off, or maybe I do. That's going to be because of another case that I had. I don't know that I could hold Beal responsible for that. And the reason is that the city of Ypsilanti, during the pandemic, whenever that began or ended, the inspections for COCs weren't happening. And then we're beginning to get rolled out in a very bizarre way.
So Judge, we are aware that there were globally issues with inspections. At this point, the issue is just that we are not getting a complete response. There were also interrogatories that addressed that question. And so a response to the interrogatory could have been, well, we applied for a CO on this date, the inspection didn't happen until this date, here's what we have. We're not getting that. And so one of the things that we thought the court might inquire today with Mr. Beal present is what Beal Properties record keeping methods are. If the business does not retain records of correspondence with the cities in which they operate, if they're not keeping on record.
Okay, but that information should be obtainable through the city of Ypsilanti.
So as I mentioned, I can't remember if it was last time or the time before, we can also subpoena the city, and likewise for the Misha documents, we can subpoena Misha, but that doesn't relieve Beal Properties of their disclosure obligations.
I get that, but I think in this particular instance of the inspections from the city, or what I've seen, and it may just go to this particular issue, that the city is going to have more complete records than the landlords.
That might be the case. And again, if we had gotten a complete response in February or whatever it was when we initially did our discovery request, if we got anything resembling a complete response, and then we could subpoena the city and get the rest of it. We have been going back and forth with these just extremely inadequate responses. And again, this is just one category. There are other.
No, I get it's the one category, and I'm trying to resolve that one category.
Okay.
I think regarding the inspection to the city, the best records are going to come from the city. And part of the reason I say that, I mean, there might be issues about what Beal received, what was their response to that. But, and I'll just be blunt, there are landlords where the city supposedly sent certain things, but I see a pattern where landlords did not get that. And so that might be an issue, but.
Right, so we have, again, from our client, we have 2 letters from the city that indicate deficiencies that needed to be addressed, not only in her unit, but in other units as well. And then eventually, the unit passes inspection, they get a COO. So somehow someone knew that there were things that needed to be addressed before the COO could be issued.
Yep. That's where I'm at.
Maybe not.
I'm with her.
Maybe.
Okay.
Well, let me put it this way. Somehow they knew. The question is how they knew and whether or not, and I'm going to suggest to you that that's going to be more complete within the city's records than it is in necessarily an individual land.
And Judge, we're happy to and plan to at this point send a subpoena. Again, because we've been in this extensive back and forth and had to take so much time to communicate what is still missing when it's pretty obvious what's still missing. We've had to prioritize. I mean, we have this court date coming up. We're trying to get back to Mr. Ingram timely because we know there's the $100 a day sanction that you held out there. I didn't want that to be, I want that to be fair. And so we spent time going through what they gave us and again, detailing the deficiencies, which took a number of additional hours. And so that's been where we put our focus. On this particular point, I take the court's point and we will give an adequate time subpoena to the city. Another similar category is Misha. Probably similarly, we think the records that Beal Properties certainly should have, but Misha's records at this point seem like they probably would be more complete. We can send a subpoena to Misha as well.
Was the answer to the
Your Honor, at this point, we have submitted literally everything that we have. I believe that Sister Counsel is making a mountain out of a molehill in many ways in terms of a lot of this. The probative value of some of the things they're discussing, I think, is highly suspect. I think at this point, given the fact that there has been this.
What does that mean? What does that mean that it's highly suspect?
I just don't know how all of these overbroad requests directly have an impact on the actual issues that remain in this case. So at this point, we believe that we should set the discovery aside and simply move the case forward. Whether or not, there has to be a trial, we don't know. Whether there could be a settlement, we don't know. But
it's like so hysterical that the defendant who is not producing discovery is like, we should just stop discovery because let's not do this anymore. Let's just go to trial. Yeah, I bet you don't want to do this anymore. You have all kinds of deficiencies and problems with your units. You have the city, you have Misha after you telling you don't qualify to have tenants and you shouldn't be leasing out or renting out the spaces. So yeah, I guess so. I guess you don't want any more discovery, huh? Because you don't want us to find out anything else about what's wrong with your units and how you shouldn't be collecting rents.
But I think the whole situation with discovery has been protracted, to say the least. We have provided everything that we can provide. Mr. Beal was.
Well, here's the problem with that, counsel. I'd like to believe you, but that's not what happened. I mean, you told me that before, and then there was more.
So you lied to the court.
In terms of being suspect, I'm a little suspect of that statement.
I believe that Mr. Kennedy employed different methods the last time that he searched the records. And there were a few more things after Sister Counsel sent us a letter.
He employed different methods to search for the responses and found more responsive documents. So how did you look the first time? Decide if you should or not? Like, what do you mean? Did you open up the file ever?
He employed different methods the last time that he searched the records. And there were a few more things after Sister Counsel sent us a letter suggesting that we think that they might want. We were able to find things that were responsive in terms of that. But at this point, the well is run dry. There just isn't anything that we can offer.
And again,
well, it's
you
dry.
told me that before.
And something
and
came
then there
up.
was more.
Yeah, you're not trustworthy.
So I don't know why I should take it now. That's the problem, right? That's the problem when you don't comply with discovery. I mean, and all of a sudden come up with more. So the MISTA documents, you don't have all of those.
No, we don't believe so. There's indication in emails from Mr. Beal saying that there was another inspection at the end of April that was passed. There's no documentation of that. The only thing we have from Mishta afterwards are the termination notices, and then an email confirming that there needs to be no further inspection. But this is after the termination notice. That was the contract was terminated due to administrative, not the fact that the deficiencies were cured. So this goes to the conditions of the apartment, whether those were ever cured, and we don't have any proof of that. Though Mr. Beal in emails claims that there was a second Mishta inspection that was passed, and there's communications indicating that he was interacting with Mishta that we don't have. So all of those are responses to the discovery request that we do not have.
Where are those documents?
If we did not provide them at this point, my clients informed me that they are not here, that
Here,
they don't exist.
they don't exist.
Okay, but where are they?
But you
I mean,
said
if he had communication with Mischief regarding
Yeah.
an inspection,
then they should exist, right?
wouldn't you keep those records?
I cannot speak to that, but again, I
Oh,
have,
you want me to address your client directly? I mean, somebody's got to have the records.
Right. Told you they playing games.
again, my client was just reminding me at the court that Mishta should have a complete set of the records, and
Okay.
Okay. Oh my gosh. Oh, that's like, okay. So the judge gave like this kind of extensive rundown with the plaintiff, which is true. You can subpoena the third party, the inspectors for their documents and ask them to provide, just like you can subpoena medical records from the doctor's office if someone's claiming some type of medical illness based upon their complaint, right? They got in a car accident or whatever. But at the same time, if you do a discovery inquiry, if you ask in an interrogatory, do you have medical records relative to this? That respondent can say yes, and they are Bates labeled 5 through 500, please see attached. And you add those to the documents. To say, oh, well, they can just go off and subpoena all these other entities. One, it costs money to subpoena entities because you have to pay the entity for the record that they produce. Atypically, I don't know if the MSHA or the city inspector will charge them, but if you're doing medical records, the hospitals will charge whoever is subpoenaing them per page to produce. And so I assume that so with these inspectors. Two, this is a business. You're the business owner. You're not an individual producing medical records. And the reason why I give that analogy is because that's kind of a little more frequent where the individual will say, oh, I don't have that copy of records. They're somewhere in the garage. I don't know. I don't really know how to get to them. I haven't seen them. I didn't keep them. I threw them away. And as the opposing side, it's just almost more automatic. But you send the interrogatory to the complainant who says they have some kind of illness or whatever, they have an issue physically, and you ask them to give you a release so that you can subpoena the records from their doctor, just to make sure that even if they did produce something, that the doctor's production and their production is the same and complete and whole, and there's no alterations between the two. But that's an individual. As a business, you're supposed to keep business records for at least 7 years. And this is the reason why you're supposed to keep them for at least 7 years, because if something comes up, whether in court or some other administrative proceeding, you have records. You have a custodian of records, and you have those records kept, and you can give the records over if need be in discoverable measures. And if in fact it's after the 7 years, then your custodian of records gives an attestament, and they do it under penalty of perjury, saying that those records were destroyed in the normal course of business on such and such day, showing that it was done after the requirement of keeping them for 7 years. So all of this, well, they just go and subpoena elsewhere. It irritates me because this is a business. If you're a landlord, you're a business, and you're supposed to have your records for at least 7 years. I shouldn't have to go subpoena everybody else. Where's your records?
I understand that, but there's correspondence. Mr. might have them, right?
it's possible,
But your client should have them too.
Yeah.
unless they were deleted. If they're emails.
Well, were they? Where's your custodian of records?
The assumption is that all of the information is kept. That's not necessarily the case.
Was that the response that they got, that it was deleted?
Do eDiscovery
Mr.
instruction.
Kennedy's sworn under oath that whatever emails and so on are there are the ones that have been retained. So the assumption.
Well, counsel,
And then
it's
you
not
found more.
assumption. If you no longer have the record because they are deleted or you don't retain them, then that's the response. But my understanding is that's not the response
I believe that,
because it was just an absence of a response.
I believe that was the sum of the response, Your Honor.
The sum of the response. Counsel, somebody asked you a question about an email. You either say, I don't have it because we don't retain emails at whatever point.
Yes.
Or you say we do have it.
Yeah.
Right? I mean, so I don't know what the sum of I don't understand what you're telling me in terms of the sum of his response. They're not supposed to be guessing what the response to the discovery is. They ask the question, you answer.
You respond.
If my client says, Your Honor, with respect, these are the emails that exist, there are no other emails, then I think that it's fair to assume that they would have been deleted it.
He has got to be kidding me. He has got to be kidding me. He's actually saying this right now? Okay, this would be something you would say at the hearing before them, like during the motion to compel. Like, my client has represented, this is a full and complete copy of all discoverable emails and documents. We are not in possession of anything further. So we don't understand why opposing counsel is coming before the court for this motion. But the motion was granted. They are here to show cause as to why you have not fulfilled the order of that motion. And they're being charged $100 a day in sanctions for non-compliance. So you got to get to a point where you comply. Once you get to a point that you comply, then that's going to be the total amount of money that they're going to have to pay over to the plaintiff for even having to bring the motion to compel it in the first place. And judge just said, you came in during the motion saying there's nothing else that exists. They went and did another search because you said he employed different methods to search, and you did another search and you found more things to exist. What were those other methods? Were they a full and complete method? So that, and if so, who says? Like, you should be doing an eDiscovery extraction at this point. Because quite honestly, no one can trust your word. We need an expert to come up here and say, look, this is all that exists. Because your word and your client's word is fast and loose. It doesn't mean anything because your actions have shown that you have been incorrect and lied to the court, whether it's lied to the court because you knew you were lying or lied to the court because you didn't know what you were doing when you were looking in the first place and happened to overlook things that were actually responsive.
No. If I got that answer, I would assume that there weren't emails that were sent, that they never existed. There's a difference between whether something existed and has been deleted or never existed at all.
Exactly. That's right.
And it sounds to me like the response was that they didn't exist, which I would think on their part would raise a red flag because they know certain things exist and you're telling me they're not there. So were they deleted or not?
Those would be questions that I think are better put to one of my clients or
The who? One of his clients? Is that what you said?
What's the next category? I'll come back to it.
I'll put the next two categories together, and they're just generally under the bucket of communications. We have requested all communications with our client, Mrs. Jackson, and we didn't receive a complete packet of that because Mrs. Jackson had other communications that we voluntarily disclosed to defendant. So we just believe that given the nature of the lack of response to that discovery request, there are possibility and the inadequacy of other discovery responses, that there's a potential that there are more communications missing. And then same with internal communications. We originally had asked for any internal communications discussing Ms. Jackson or her unit, and they produced none, claiming that all of the communications were done orally. And then when pressed, they produced only one communication. And we just are not convinced that given the repeated instances of incomplete responses that is true. And so we would request that your report confirm that with Mr. Beal here today.
I don't know what Mr. Bill's role is. I think he sounds like he's like the CEO, or maybe he's the manager. I don't know what his role is. It's a team of people. I'm not sure where he falls into this scenario. Sounds like maybe that Ms. Jackson has more connection or communication with Bill, and so that's why they keep picking on him to know more, or that he's been somehow deemed the person most knowledgeable in this regard. But this is a hot mess. So every business owner alive, learn now. Do not play fast and loose with your records. Don't throw them in the sky and just forget about them. Be organized, be knowledgeable. Another thing is if you have, say, like a GoDaddy account and you're using like an email hosted by some account, you need to back that up to a server, an external server. I'm the person that prints things out and puts them in a file. That's me. I know it's an old school thing, but the reason is because I've had computers of the highest of technologies freeze up, can't find it, and I can just fiddle through my file real quick, and there it is. And sometimes it just saves me that way. So that's what I do. But if you're not going to do that, you need to find whatever system is going to best suit you. We talked some time ago about a landlord. So this is an apartment building. So these are full-on landlord companies. So you should have either a property management company working on your behalf, because clearly records are not your thing. And there are great landlord tenant softwares that you can have communications in text message form, email form, and they just get all bundled together. Therefore, if you ever need to produce, you just produce relative to the contract ID or the address ID, depending on what the circumstance is, and it makes things a lot simpler. But for this company to not have any to act like all communications were all done verbally, what kind of company are you? Because even if you did something verbally, you do memo to file. Each officer who was in that meeting that happened to be a verbal communication, that if it's a substantial thing, like Ms. Jackson's complaining about her electrical unit, and you guys are talking about how we can, okay, call so-and-so contractor to get out there. Each one of you are writing a memo to file. Talk to so-and-so and so-and-so about getting Miss Jackson's electrical looked at. We got contractor XYZ going to go check it on Monday. And then someone else might say, okay, Miss Jackson complained about electrical, contractor looking into it. And then someone else might say, because now all three of you can say, we each did a memo to file in our own words based upon what we talked about. And here is the production of it. But you're not being able to do that because you say everything was verbal means you don't keep records. And clearly you don't keep them organized if you kept them at all.
Okay.
It's
The
absurd.
communication,
Absurd.
were these like electronic communications, like an email, or were they like letters? Or both? Emails? Okay.
But it's
What are you gonna say
verbal.
to that?
So you don't have
If you,
email?
hold on, counsel, if you get up and say, well, if we don't have it, it's not there, I'm
Don't do it to
gonna
you.
scream and go run off the bench, because that's not an answer.
Oh boy. Oh good. Yes, help him. Tell him something.
That we actually went to an IT professional with the last letter from sister council, and they specifically searched for everything in their system. And the stuff that was turned off is what was brought.
So where's the report? Where's the IT report?
Okay.
Where's the IT report? Where's the person?
Then the question becomes, what happened to them? I mean, if there are communications that are there, and
Yeah, what happened to
counsel,
them?
correct me
Right.
if I'm wrong,
They were deleted.
there are certain, they say in response, there are certain communications that don't exist, right? You then have certain communications and they haven't turned those communications over to you. So somewhere, so where'd they go?
Where'd they go? Where's your IT report?
I mean, if you got an IT professional,
Yeah.
I mean, they can forensically find whether the stuff's there.
And where did and what
Did
happened?
we dig that deep, or was it somebody that just,
Oh no,
how deep did we go with this IT professional?
not the nephew IT. Wait a minute. Wait a minute. No way, counselor. No way.
If the,
I think my question was real clear, but go ahead. How do you want to rephrase it?
I'm not sure, Your Honor, you're asking me if everything was deleted directly or what?
You're kidding.
Well, I was on the IT professional. I'm trying to figure out how deep did they go? You were telling me we went to an IT professional and then we turned over everything. Well,
Right.
did they do a forensic analysis, or what did they do?
Or
Because if
eDiscovery.
they did a forensic analysis, I want to see it,
That's criminal.
right? If
eDiscovery.
it's somebody that calls themselves an IT professional and I just went through the files, that's one thing. So that's what I was specifically asking about. Was this IT professional able to determine that they were deleted?
Oh,
I
Judge,
don't know this one, Your Honor.
good call. Judges like you.
You don't know the answer to that.
So you don't have a report. Where's the report? Oh no. No way.
And so how do you tell me we got an IT professional to come in
No way.
and they told us that's everything that's there, right?
Correct.
Not even professional. It's not even
And
professional.
then I ask you, well,
Where is it?
are they saying that it was deleted? Or are they saying, I mean, did this IT professional do a report?
No, but my client is here.
Well, sir, did they do a report?
We gave him the discovery questions, and he provided the emails in answer to the discovery questions.
No, IT professionals don't do that. eDiscovery, no, they don't.
The answer to your
respond.
question is no, he did not provide a report, he just answered the discovery.
Okay.
No, they don't. Oh,
Was this somebody that was this an IT professional, or was it just somebody going in search of stuff?
His name is Lance Eisen, he's our director of operations, he's worked in our IT systems for more than 10 years.
I'm dead. I'm dead. I'm dead. So I don't know this counselor. I don't know him. I don't. But he does not know what he don't know what he don't know. He don't know what he don't know. That is it. That's a shame. Okay. Okay. There are IT professionals. It's a niche to be an eDiscovery anything, right? eDiscovery secretary, eDiscovery paralegal, eDiscovery attorney, eDiscovery IT company. And to say the IT professional works for the company and he's over our IT systems, but he didn't do a report and he responded to the interrogatories. He's just, that's not at all. That's nothing to do with what we're talking about here. It's the same as having the CEO respond or the custodial of records respond or the person PMK most knowledgeable to respond. It's not having well, just saying forensic, but yeah, it's not having the eDiscovery forensic IT company. Because now, all law nerds, raise your hand, put it in the comments. If you are a depth V herd aficionado, then you're listening to this and you're like, what's the metadata? What's it? You are having PTSD right now. So I'm sorry. So, cheers to you, drink it up because it's a moment in time. You got to be kidding me. If you remember the extensive time that, what was his name? The one on Depth's team, he dealt with experts. When he kept going into all of the particulars on how you do the extraction, what was the software? What was the license number of the software? What's the expiration date of the software? Because an IT professional that deals with litigation and e-discovery is not doing a Google search like you and I are doing, looking in your email and searching by a word grant, and you're seeing, that you have this word come in all different emails. The IT professional that does e-discovery is going behind and scraping through all of your drives, all of the computers. They're coming up with a report that lets you know these are the number of computers that had something to do with this file or this matter. These are the number of emails that went out. Some of these emails are no longer in existence because they have been erased, or the software updated and erased it, or you got new hard drives. And so consequently, there's a gap in information. They start talking about the metadata that tells you, here's the document, and this document, though it says, please see below, you can tell that the information below in that email has been altered. They put the word approved. You now have a clearance to occupy, whereas before it said not approved. You don't have a clearance to occupy. That is why having the IT professional that deals with litigation and e-discovery, electronic discovery, a niche, and it's important to have the ability to respond to the interrogatories. But the attorneys respond to the interrogatories. The custodian of records will give the response to interrogatories. The general counsel is usually the attorney that works for the company, but yet the attorney for trial could be somebody else. So that particular internal attorney will give the responses to the representative attorney that will then submit them over to the opposing counsel. It's such a process. You, as an IT professional, would not know how to answer, should not know, and would not be responsible for knowing how to answer the interrogatories, because the language that should be used, the objections that should be inserted, the different parameters that should be defined by, because there's only so far back you have to go. You don't have to go back into infinity, right? So you have to make sure that those things are in order, and that's done by the attorney, the legal scholar. But the IT professional does the extraction and tells you what the data says, and here's the information, and here are the documents, all the documents that relate to this person. And then it's up to the professional to decide if all of those documents are the same person. Is that the same Ms. Jackson, or is that a different Ms. Jackson? Is that the same lease in question, or is it a different time that she had a lease with them? Maybe she moved from one unit to another. And so then they get into what is actually meant to be responsive and what isn't. So all this fast and loose game playing is hogwash. And quite frankly, I'm completely offended that we have wasted the court's time, 40 minutes or so, to get him there to only tell us that you had some professional who's not professional enough to do professional things like do e-discovery and litigation, perform a search on some server to find out if you had more documents.
Okay,
Nephew IT.
maybe. So, and maybe we had different views of this. This IT professional just went in and searched based upon a particular criteria to find things.
That's right.
That's what
Right.
happened.
Right.
That's something different than a
That's-
forensic type of an analysis of what's there and what's not there.
Right.
That's right.
So in essence, this person only could say, this doesn't exist in our system, but can't say why it doesn't.
That's right.
Maybe. I would say maybe, because there's IT professionals that do networking, and networking is like connecting everyone to the network in certain regards and pairing up certain departments with others. And then there's IT professionals that do data protection. So they make sure that all the software and all the data is being protected. So I don't know, this IT professional is not here. He may not can say that it doesn't exist, that it's not in our possession, because it could be in a temporary hidden file. Because did he look through all the files? Did he use any type of software to do an extraction of files? Even if he's not an eDiscovery IT person, what software did he, he just searched, but you just searched. So how are you searching? What words are you using to search for?
All right, then I'll ask the $1 million question. Do we know why it's not there?
I don't know. I haven't seen the document that they have that we don't have. I don't know what we're speaking to.
It just said like 30 minutes. You say you have courses that you didn't produce.
What's the next category?
Those are the last two.
Those are the last two.
The communications that we believe are missing.
So it's communications and then the mischief.
Yeah, Michigan and the city of Ypsilanti would be covered.
Communications being the internal ones.
internal and with our client.
Mr. Beal, what happens to communications with tenants?
I communicate via email with them.
Okay, and then is there a policy regarding retention of those?
Retained via Gmail's policies. So I don't save them, they're just in Gmail.
You're using Gmail to house your emails? Gmail does not erase your emails. And so you're searching Gmail for things. Do you put them in automatic label folders? He's
So other than Gmail, because that's
Yeah.
used Gmail. I know.
Well, it's Outlook. It's Outlook. It's Gmail behind Outlook.
Okay.
it's Gmail.
And so there's no policy that says we're going to keep all communications for X number of years.
Hmm. Hmm. You have business compliance record issues, business record compliance issues. Hmm.
So if somebody were to go in again,
Mhm.
your belief is that there would be nothing else that's responsive to their inquiry.
Based on what?
Is that correct, Mr. Real?
I believe we've answered the questions with the documents that we've already defined. I mean, they spent a lot of time on it.
Why did your attorney? The attorney should have known better. The attorney has the right to, so the attorney should have said, okay, so where are your documents? Usually, how do you communicate? Oh, we do it through Gmail. Gmail, okay, under what account? Just one account or several Gmail accounts? Okay, all the stuff that the judge is asking. Then the attorney should say, okay, you know what? I'm going to hire a third-party expert. You're going to pay for it, of course. And they're going to do a full extraction relative to these documents so that we can get this over because we have a motion to compel. At least the second go around. The first go around, you should have did it, but you didn't. Okay, but when the motion to compel was granted against you, you should have known to hire a third party to extract documents and records and to say only on the Gmail. So you don't have a server. Where's your server? Where this? Whatever. Whatever.
So
Don't you do business like this, landlords? You've learned.
this
Okay.
last exchange between counsel,
Okay.
is there a definitive statement that we don't have anything else?
Yes, Judge. So so after our last court hearing, the very next day we received an initial response from Mr. Ingram. It was mostly the prior response reformatted with a couple of little additional points that I specifically mentioned during the hearing. In response to that, I sent a detailed letter, including, and I say I did because this was between the semesters, including examples of documents that I think would be responsive that we had in our possession. I actually attached those documents so that Mr. Ingram could see exactly what's going on. In response to that, we then got this most complete to date response, including that it was signed under oath by Mr. Kennedy. This was the first time their response to interrogatories was actually signed. And because I specifically asked in that last request, I'm asking for this or a statement under oath that no such records exist, something to that effect for various questions. And so the answer that I got back was, again, very small addition, like one additional exchange, and they've searched their records and nothing else exists. So that was what we got back, which is why we did indicate to Mr. Ingram that we were, at that point, I felt like there was nothing else we were going to get from them through written discovery short of appearing in front of your honor to discuss this issue. We did mention to him that we believe that there were continuing issues and that we would be inquiring or asking the court to inquire about the file keeping processes. So it's not that we communicated that it was complete, it's that we communicated that we didn't think we were going to get anywhere else, just between the two of us or the four of us.
Was the last response you got, was that under oath, signed and under oath?
Correct.
It was the last response?
By Mr. Kennedy.
And what's his position with Beal?
Your Honor, as counsel actually stated, yes, we did provide detailed discovery last time, and I believe that we answered.
To answer the question, what is Mr. Kennedy's position with Beal? What does he do? What is his title? Who is he?
I know that we answered to the best of our ability everything that could be answered. Some of the answers, for instance, all documentation that currently exists has been provided.
Judge, if I could, Mr. Kennedy's position is assistant property manager.
Thank you.
However, he was not the property manager for the property in question until I believe it was April of 2022. Mr. Beal was the property manager for that property up until April 2022, which is why Mr. Kennedy told us during the deposition that there were many questions he couldn't answer, and why we are a little bit mystified that he continues to be the person who is currently responding to the written discovery when he has told us that he doesn't know the answer to many of these questions.
Girl, what? Mr. Bill he is ducking and diving, boy. He don't want to come to court when he was ordered to. He doesn't want to answer discovery responses. And I am so appalled that well, I mean, you don't have to verify discovery all the time, but we talked about verification before. I say get your client to verify because it protects you as an attorney. The client's verifying that, yeah, everything there is correct and true. Verify your answer, verify your discovery, even if it's not necessarily required, depending on the situation. But so she got him to verify the last discovery. That's all they had, but that's from the property manager who was involved for only a month or two, and this is something that happened before him. And why can't that attorney answer the question? Why is she answering for him?
From the beginning of the tenancy.
Mr. Kennedy has the most familiarity with this particular situation. That's just a statement of fact, more so than Mr. Beal.
What? Why would Mr. Kennedy have more connection to this issue if he was not the manager of the time? Are you saying that Mr. Kennedy is more intelligent than Mr. Bill? Is that what you're trying to
That
say?
there were many questions he couldn't answer, and why we are a little bit mystified that he continues to be the person who is currently responding to the written discovery when he has told us that he doesn't know the answer to many of these questions from the beginning of the tenancy.
Mr. Kennedy has the most familiarity with this particular.
Mr. Kennedy has the most familiarity with this situation, but he's not the property manager at the time. So Mr. Bill was out of his league as property manager. Okay, got it. Thanks, counselor. We understand now.
Situation. That's just a statement of fact, more so than Mr. Beal.
Well, but there's a certain period where Mr. Beal's involved in. He's not. Mr.
Yeah,
Kennedy.
he's being nice. He's just saying Mr.
Right?
Bill's dumb. He doesn't know what he's doing.
Rephrase it.
Or
At
you're
some
dumb.
point, Mr. Beal is the one that is dealing with the property.
In a management capacity, yes, for general sorts of decisions. But the day-to-day operations for specific tenants are handled by Mr. Kennedy.
Judge,
Go ahead. Yes, go ahead.
during the deposition, we went into this specifically, and Mr. Kennedy said that he was not the primary, or I don't know if that was the exact word used, but he wasn't the property manager until April 2022. Mr. Beal was the property manager for the property. He was the assistant property manager, and so he may have had some interactions, but there were a number of questions where he said, I don't know, because I was not the property manager for the property at that point. In April 2022, I took over management of the property.
Remember, the tenancy started September 2021.
So it sounds to me, though, that there are a number of people that may be able to provide this information if it's there. And part of my problem, counsel, is it's one thing with discovery if I say I'm giving you these documents, and it happens all the time. All of a sudden I go and look and I said, I don't know if I gave this to you. So you just supplement the answer and you send it saying oversight.
Mm-hmm.
And that certainly is understandable. That can happen with anyone. I don't get the sense that that's what's happening here.
No.
Because what seems to me to be occurring is questions get asked, and not until someone comes along and presses do I get other responses. Like nobody goes and looks. Nobody does anything until somebody has to say you should have more.
I understand that that's the framing of it that Sister Council has put forward, but
No. That's what I've seen.
Dare you try to act like the opposite? Sister counsel is the is the name of the company or the counseling that's representing Ms. Jackson. How dare you act like they are just putting forth? It's like he acts like this is a motion hearing. It's order to show cause. They already won the motion. They're not just giving allegations to the way you're doing things. It's been proven that this is the way you're doing things because you had some discoverable issues that you didn't turn over until much later. You're being sanctioned. You're being sanctioned $100 a day. Courts are like, they don't do that just to do it. You have to have done something egregious. It must be proven to them that you're withholding information for them to sanction you, or you did something so fast and loose that they're like, okay, you need some money problems in order to make you work faster and efficiently. And they're still not being efficient.
Has nothing to do with what they said, other than they explain the circumstance. It's what's happened.
Yeah.
It's like nobody. I don't know, Mr. Beal, you were going to say something, sir. or wanted to.
One of the issues is that the requests are not specific. So if you were saying, please provide me the inspection report for the inspection that occurred on August 16th, 2021, we could email the city and say, please provide this. We could kick it over.
That's why attorneys are supposed to do the talking. Because it's not the plaintiff's job to know exactly when the inspection happens, because they're the tenant. You're the landlord. You're supposed to know when your property was inspected. You should have a file on it. You should know. And what they should say is, between August of 2021 to the present day, please provide me any all city inspections from August of 2021 to present day. Please provide me inspections from all Michigan, whatever the other one was, right? But you want them to know what day they actually came out. And it sounds like they came out more than once, and they inspected more than once because they found issues with it more than once. And so now not only do I got to know one of them, I got to know all of them too. I got to work for you. I'm not your record keeper, that's you.
Not to them, but they're saying, please provide an inspection record that may or may not have occurred. We don't know.
Why don't you know?
Well, but my answer to that is this, and that is, they say provide all inspection records for this unit located at whatever. You can go to the city and ask for that.
You should have
Provide
it.
everything in our possession.
But your example that you just gave, where you'd say if they were specific as to something occurring on a particular date, if you didn't have it, you'd go to the city. What I'm saying is, if they say, even in a date, I need all the inspection records as they relate to this unit, why wouldn't, under that circumstance, you go to the city and ask them for all the inspection records? I mean, what's the distinction between the two examples I just gave in terms of what you do?
Whose responsibility it is?
Well, I think the answer to your question is we could have done that.
You should have done that.
And if you'd like us to do, we can do that.
Okay.
Oh my God. This is what his attorney is for. This is why the attorney is an attorney, because they say, wait, you don't have inspection records? No. Is this all the inspection records? Yes. Did you check with the city? The city, what did you open from? You weren't the owners during the whole time, or you weren't the property managers during the whole time. You'd go down to the city, right?
And if you'd like us to do, we can do that.
Okay. Here's what I'd like. I'd like, discovery is supposed to be self-executing. I think I can speak for every judge. They hate dealing with discovery motions.
Yes.
But we'll deal with them when we have to. But that requires fairness in terms of what somebody's looking for, as well as fairness in terms of the responses that are being given. And I don't think that's happening.
Can I respond to that?
Sure.
No.
Okay.
But
The case is about the return of the security deposit, so all the discovery requests are not applicable to the case. So
Okay, so let me give you a little legal lesson. Discovery is not only about things related to the case, but other things that can lead to discoverable information. Since a security deposit can involve a claim for damages, it seems to me that anything having to do with repairs to the unit, the condition of the unit, when that condition happened, or anything else along those lines would be relevant.
I appreciate your opinion on that. I agree.
Well, good. Been doing this for a minute.
Well, Judge, hit it.
So, folks, how do we resolve this? Because here's the other part that I don't have. I don't have Mr. Beal's statement that, as the manager of this, that everything has been searched for and that we provided everything.
And it hasn't, because they didn't go to the city.
So there are two ways of doing that. One would be that I order his deposition taken and I give you a date when that will happen. Or it could be done in writing. I'm going to prefer, so that it's a better, I'm going to set a deposition date.
I think that's fair.
So of Mr. Beal. And then that way the questions can be asked and there's going to be a responsibility to do that. And then I've got a record of what's done. Yes, sir.
Can we divide that into the three categories?
Into the three, you want 3 depositions or what do you mean?
No. So we can simply copy them on an email to the city asking for the full file for the property. There's no need to subpoena the city. And we can email Mishta and ask them for the full file and copy them on the email, and no reason to subpoena Mishta.
Oh my God. Oh my God. His attorney needs to help him. I'm telling him to shut up, and that's rude of me. I shouldn't do that. I apologize. I'm irritated, but at the same time, I'm a professional in the field of real estate. I'm a professional in the field of legal. So I have irritation with him and the lack of records and the, the kind of whatever record thing is going on. but his attorney should be letting him know. This right here is not, it's not helpful. You can't make their, I think what he wants to do is make their questions kind of like categorized questions, but their questions are going to be relative to what they need to know. And it's the whole case, and you have to report the whole case. Now, yeah, you go out there and go look for those records, but you should do that before.
Deposition now is just about our communications.
No, no,
That's what I meant. That's what I meant by the three categories.
what are you talking about? No, it's not how it works.
Judge, so the documents are a big piece of what's missing. We actually had discussed earlier with the court the possibility of deposing Mr. Beal because I think there are quite a few questions we would have for him that Mr. Kennedy was unable to answer that wouldn't be answered simply by documents. So we would like to depose him. We would like to have as many of the documents as possible before the deposition. However, if
I don't know if that's going to occur. I mean, I understand your point in that, because what's going to end up happening is there's going to be a deposition about the documents. Then people are going to get documents, and then you're going to request another deposition.
yes, and Judge, I just would like to point out we're the plaintiffs in this case. We have no interest in drawing this case out any longer than it needs to be drawn out. But we have
I don't know. No, go ahead.
But there's more than the security deposit at issue. I mean, as pointed out, conditions are implicating the security deposit, but we have MCPA claims as well.
Yeah.
There's a lot going on in this case that's actually relatively complex as far as these matters go. And we would like very much to resolve the case short of trial if we can. We have made ourselves available for conversations. That's not an invitation that's been taken up at all. So we are proceeding towards trial, and we don't want to conduct two depositions, but if need be, that's what we'll do.
Again, we don't object to Mr. Beal being Congress.
So that's a start. All right. So when are we going to do that? Look, folks, Mr. Beal, you guys know what documents they're looking for.
Yeah, we do now. Yeah,
Pardon?
we do now. Yeah.
So what I'm going to suggest is that wherever those documents come from, if you can get them easier from the city of Ipsy and you can get them so that they can just do one deposition and ask you about it, just do it. Because you could not do it, but ultimately it's going to happen.
The city's very easy. The Mishta will be very difficult, but we'll make the request.
I know Mischief can be whatever Mischief is, but so when are we doing his deposition? 'Cause
And the communications are the
I know, I hadn't forgotten about it. I had not. So when are we doing the deposition? You want me to set a date?
I think one question is how long it will take to get the documents.
2 weeks. 30
My
days.
client says he's fairly flexible, although he will be out of town next week. So sometime after next week, we'll probably.
After next week? Okay, so here's the other thing. Your search by the individual of this IT person for communications. They did a search, like I said, I'm sure they had some criteria that they listed out, right? Or that they used to do their search. I get that. Yeah.
If I may. With respect to the communications with Ms. Jackson, that's pretty, I mean, my 12-year-old did that search. It's all communications. I mean, I shouldn't say that.
Yes.
Much better at this.
She has a
than
bright 12.
But it's all communications with Ms. Jackson, which then they can go through, and if there are communications that are not responsive, they can eliminate those. But that's not a difficult search to do to get the initial batch that they start from. And likewise, I would think internal communications about conditions at this property. I would think that most of those emails would in some either mention her by name, mention the address. I don't know if they have some kind of internal number they use for the properties. That does not seem like actually something that even an IT specialist is needed for.
Well,
Being
no,
an IT specialist.
I get your point. And it's the one thing that we don't know
You know, do eDiscovery.
because I don't have that person here. I don't know what criteria they used. I agree with you. It'd be a simple process, but I don't know how I don't know how the data is stored. And I don't know what search criteria they use to go through that data. So it's impossible for me to say that it was an easy search, only because I don't know those two things. But what I am saying is I want to give enough time so that somebody is looking at it and that they search again. That's what I mean, if they didn't use the word Jackson, I don't know why they wouldn't. Then the first time, then they need to do it this time and give them the opportunity to do it. So how long will that take?
No time at all. We can do it soon.
All right. So when are we setting the deposition?
I'm sorry, Judge, I missed it. How long did you say?
He said it wouldn't take any time at all to try to get that done.
And then there's also the Michigan City.
So I think perhaps we can just put the date on us doing, I imagine, another mail search. And then providing the other documentation.
Talking.
Okay, so I'm asking, how long is that going to take you to do, or a reasonable estimate, so that we can set a deposition date?
Give them 3 weeks.
My client suggesting at least 2 weeks for the city to respond. I think that's probably reasonable.
Understood.
And Michigan.
Okay, well, yeah, good luck on that one. And then within that same time frame, you can do the search of communication. Okay. So 2 weeks out is October 3rd. I know that now. So when in October do we want to do the debt?
Over 10.
Be available. I'm not sure how many additional documents we're gonna be looking at, so I would like to give ourselves at least a week to look at that. So, no
Okay,
earlier
yes.
than October 10th,
Like
Okay.
I do this.
but we also would be available the following week on the 17th, 18th, or 19th.
Hmm.
I'm sorry, not the 19th, I'm going out, 17th or the 18th.
My client's going to go from 10th through 20th.
So that we got.
Okay, so then if I'm looking at October,
What's that
what's the
sound?
availability of people the week of the 24th?
We're okay that week.
That's fine, that's fine.
Okay, you guys pick a date. I'm just here. I'm going to write it down.
Your number.
We can propose October 23rd, Your Honor.
If we do the 24th at 10
Of course they wouldn't agree. Can you do the 24th?
What is the 24th? Is this?
Yes, but can we say 11?
Yes, that's fine.
Okay,
So the deposition of Mr. Beal will be October 24th, 11 a.m. I'll let you guys work out the details as to where that's going to occur. They're going to be 2 weeks to request documents from MISHA, the city, and to do another search of internal communications. Anything else we need to do today?
Judge, we had left the sanctions matter open until today.
Yeah, keep that going.
It's not fine if we're,
Yeah, it was going to be $100 a day until it was.
Yeah, keep it going.
Okay.
Keep it going.
At some point, either they did everything they possibly could do, or they didn't. And there have been these things going back and forth. I'm going to reserve ruling on the sanctions until we get to the other part, because I don't have it clear, because I don't know, much like everybody else, what's going to show up. Right?
Right.
and sorry, do we have a date
Did you guys want to come back?
back? I know you never want to see us again.
No, that is not true. I enjoy people. No, I do. Why are you laughing? I do. Give me. Oh, this would be perfect. Oh, no, we can't do Halloween.
We have prelims.
We have prelims that day. That's my other nightmare. All right. All right. And so we'll
Other
adjourn this then to
nightmare.
November 7th, 2023, 9 a.m. in person.
Wait, is that?
That's election day. but
That's
of course.
election day. Yeah.
Yes.
Okay.
Is it election day? It is,
It is.
even though we're not here. Mr. Beal, thank you for coming down, sir. Thank you.
Yeah.
All right.
All right.
Okay. On the
All right. So, was it painful for you? Oh gosh, anyone who's practicing, anyone who's in the legal field is going, what are you talking about? They mean, what's simple, and as you said, a 12-year-old or 14, 15, 16-year-old can quite simply search emails in Google and find things. This is true. It depends on how much effort you want to give to it. And Mr. Bill seems kind of flippant about it. He's like, just a return of deposit concern anyway. So, the inspection, who cares? Well, dummy. Yes, the what? If it was broken, if it was improper, if it wasn't up to code, it's not the tenant that needs to be paying for the fix. So if it's not working and you're charging her for all these things that are not working, but they were your issues that you were supposed to be fixing, you can't hold her to security deposit. And if it's not that big of a deal and you don't want to put this much work into it and you don't want to have an attorney come to court and do it, why didn't you just give her security deposit back in the first place? And then you could have avoided all of this. You hate things. Oh my gosh. If you do things with a sense of, in case I have to go to court, in case I have to produce this in a legal matter, you'll be better covered. So being a landlord does require responsibilities. I think it's a wonderful way to build generational wealth, to own your own real estate. There's various ways to use owning that real estate, whether you're renting it out as an Airbnb, which would kind of eliminate some of your tenant law concerns. whether you're renting it out as a hostile. So some places that rent daily for hostile vacationers, whether you're renting it out as a vacation home or a month-to-month or a, complete residential annual lease, whatever you're doing. Commercial, renting commercial property, leasing that out. That can be a great way to build generational wealth, pulling from the equity to buy more and doing other things and purchasing cars. Oh my gosh, I have to teach you this. Just because we like to learn things. I know it didn't come up today, but this is very, very, very important. So just give it a minute. Do not buy a car before you go to buy your house, condo, or living dwelling. If you're renting, you do not need to buy a car. Buy your dwelling first, your domicile first, then buy your car. And if you're living in, say, a location that has some type of metro or good transportation, or you're not too far from work, or if you buy like a little, beat up car for $1,000 or less, and you have no car note, right? And you just bought it from, private person, then fine, that's fine. And then when you want to upgrade to your BMW and your Lexus and your Cadillacs and all those great luxury cars and all the other ones, whatever their names are, okay, Mercedes, of course, all that. After a couple of years of building equity in your home, you can refinance the property that you own, and you can get a loan out for the amount that you're going to buy the car for. So if the car's $100,000, then you can refinance for $100,000 and you buy the car straight out using cash. But you're paying it back through your mortgage payment, right? Well, your interest rate is typically less than you would have if you were buying it from a car dealership, because a car dealership is only going to give you 6 years to pay it back. And the interest rate is usually, I guess, what, 12%, maybe 9% at a car dealership. I know because I haven't bought cars like this in a long time, so you look it up for yourself. But then if you pull it out the equity of your house and buy it that way, you have maybe a 6% to a 7%, maybe even an 8% loan, but it's not on a 6-year payback plan. It's on a 30-year payback plan, or a 20, what did I say? If I say 2 years, a 28-year payback plan, right? So the payments monthly towards that car is much cheaper because it's stretched over a longer period of time than you trying to get a car dealership loan, okay? The other good way for buying a car is going through maybe your credit union, because they usually have better interest rates than a car dealership. But the payment plan, I don't think stretches beyond like 6 years. I think it's 72 months. It's like the longest plan I think you can get for a car dealership loan, whether it's with the credit union or the dealership itself. Whereas if you do a refi in your house, that money is stretched out over years. And so it's like a couple $100 a month more versus $700, $800 a month more, depending on what kind of car you're getting. Okay. So there's some game on that. Back to this weird case. Okay. I don't know what the attorney was doing. I don't know if he was working the file or not. It doesn't seem that Mr. Bill cared too much to be, I don't know if it's because he's sick. Maybe he is ill and he's kind of, irritated to be there. So maybe that's why he's a little indifferent relative to understanding what's going on with the matter. But the bottom line is, if you're going to be a landlord, which I think you should be, but you need to be one of a professional nature. And this is not that example. Okay. This is the opposite of what to do. If you have a software, I would rather you have a landlord software to do your communications back and forth. They can, email you in your Gmail account, but you can back that up on a hard drive, have it back up every maybe, I'll say every 7 days or something like that. Because if you stop payment on that particular account and you lose the account, then you'll lose your information, right? So you don't want that to happen. That's the same thing with GoDaddy's emails and whatever email hosting you're doing. If you're not paying that and you don't do it, then they erase, and so does the documentation that go along with it. So you need to back it up. You need to talk to someone about what does it mean to have a business record plan? What's the retention plan for business records? What is the requirement by law? How many years are you supposed to have those records? And then, develop that understanding. But this right here is just not what to do. I don't know a situation where Mr. Beal and counselor expressed any parts of what they were doing right. I forgot, because I just heard a whole bunch of things that they just shouldn't be doing differently. The other thing is, when you are being asked to respond to discovery, you are responsible for looking through your records. And if you don't have an inspection, you're like, wait, we had an inspection in April. Where's that report? Where's that? Then you do this. You call the city yourself. You look for the things that are in your possession. But once you're made aware that the things that are in your possession have missing pieces, you start doing other things to, try to find them, if you will. One of the strongest ways to determine if you have everything, is when you are responding to records and interrogatories. The other side should be responding to yours. Like you're asking questions too. I never heard if they did that. It's like, if you ask, give me all your documents, and she has all these documents, And then you're like, wait, there was an inspection that in April? Do we have that? No, we don't have that. How did she get that? What was that? What was that? Those are things that will help you to identify if something's missing, especially if, if you don't remember or you weren't a part of the case at the time, if you weren't part of the management team at the time. If her records come back showing you more information than what you have, that's a great indicator that you don't have all the records and you need to do a deeper dive. It is costly to have an eDiscovery company come in and do a real cleaning and search for things, because they do an actual search for things and they're good at it. And it's time consuming and it takes a particular understanding. Okay. But under circumstances where you're being sanctioned day to day, $100 a day, you may find it more advantageous to search for an eDiscovery IT. They can do litigation. Okay, you want them to do litigation. So like the Judge Simpson said, did you get a forensic IT person? What kind of IT person was it? Such a great question. Just such a, I mean, I'm just knowing that the attorney knows if he's going to represent that they had an IT professional, that it should have been someone who does eDiscovery, that has certification in the matter, and that goes through the forensic process. They actually go through and look at the metadata and they actually pull things. It's almost as if I forgot the debt to be heard case, but I'm sorry, I gave him too much credit because Judge was able to find out, oh no, it's just the IT tech guy in the office who can tell you how to reboot your computer when it freezes. Okay, I'm sorry, but I'm just saying there's a difference. So good luck with that. That was interesting. We avoided a bench warrant. So I thought he was going to jail. He didn't do that. He did show up. So he's alive. I don't know how well he is. So hopefully he'll get better. All right. We wish Mr. Bill to be better, whole, and all things together. I hope that you have learned a lot. And if you find that you have, share this with someone else so that they can learn just the same. Make sure you like, share, and subscribe. I'm Lyric Armstrong, your real estate agent and advocate. And I'll see you in this video. Poor Mr. Bill. Somebody send Judge Simpson some love, okay? Look at what he's dealing with.